We're privileged to have here Judge Diane Sykes as the moderator of our next panel on economic uncertainty and the role of the courts. She was appointed to the Seventh Circuit Court of Appeals by President George W. Bush and began service on July 4th, 2004. A very wonderful date to begin. She previously served as a justice on the Wisconsin Supreme Court. She had practiced in Milwaukee at the firm of White and Hirschbeck and had clerked for Judge Terrence T. Evans. She received her JD from Marquette University, but before doing so, she practiced the dark art of journalism at the Milwaukee Journal, as some others of us have done before coming to law school. She has the great distinction of attending the second ever National Student Symposium of the Federalist Society, and even a greater distinction in being the mother of two sons. Please welcome Judge Sykes.
Thank you, Joseph, for that very nice introduction, and I'm very happy to be here with you for this 30th anniversary of the Federalist Society Student Symposium. This last session of the conference today will take up the topic of the role of the courts in times of economic uncertainty. This panel will approach the subject in a little different way from last night's debate and panel. You'll recall that from time to time during the discussion last night, the topic of the role of the courts was taken up, but more in the sense of the appropriate interpretive philosophy that courts should bring to bear in their decision method on constitutional cases. This panel instead will explore the role of the judiciary from somewhat a more structural standpoint. That is, what kind of legal system and judicial model best protects economic rights and perpetuates a sound economic system. The discussion will touch on some history, some theory, some legal doctrine, and some empirical evidence, starting with the Treaty of Paris and perhaps a little bit before that, moving through the founding period and up to and including the challenges of our present economic moment. We are looking for some lessons about the economic consequences of alternative legal and judicial models and practices. Now, that's an awful lot to cover in what's left of the afternoon, but we have a very distinguished panel here this afternoon, and the panel is certainly up to the task. First up will be Professor Paul Stephan, who teaches here at Virginia Law School and is an expert in international business, taxation, and constitutional law. Among many other notable professional activities, he has been an advisor to the State Department and worked extensively on economic and law reform issues in the former Soviet states. He clerked for Judge Campbell at the First Circuit and Judge Lewis Powell on the Supreme Court. He has bachelor's and master's degrees from Yale University and earned his JD here at the University of Virginia. Paul Mahoney is Dean of the Law School here at Virginia, and he teaches securities regulation, corporate law, and contracts. He is a member of the Council on Foreign Relations, and like Professor Stephan, has also worked on law reform projects in Central Asia. He clerked for Judge Ralph Winter at the Second Circuit and Justice Thurgood Marshall on the Supreme Court. He has degrees from MIT and Yale Law School. And finally, Professor Todd Zywicki teaches at George Mason University School of Law, and his areas of expertise are bankruptcy, consumer protection and finance, and law and economics. He has served as director of the Office of Policy Planning at the Federal Trade Commission, and like our other panelists, has consulted on law and economic matters with governmental officials from all across the globe, including Iceland, Italy, Japan, and Guatemala. He was a law clerk for Judge Jerry Smith at the Fifth Circuit. Professor Zywicki has bachelor's and master's degrees in economics from Dartmouth College and Clemson University and earned his JD here at Virginia. So we have an all-Virginia panel in one form or fashion. Professor Stephan.
Thank you, Judge Sykes. It's an honor and a privilege to be part of this conference. I'm sorry I wasn't here the entire time, but I came in late on a plane from Denver last night, so I'm doing the best I can. My argument today is going to be that not about the importance of legal entitlements, and I'll use that phrase, but what I particularly have in mind is private law, property, and contract. It's not an argument about the a priori importance of legal entitlements, but rather a separation of powers issue about which branch of government has the comparative advantage of responding to unforeseen circumstances that challenge those entitlements. We'll start, I hope, with common agreement that stability and entitlements are good. Professor Mahoney, I think, Dean Mahoney, I should say, he's my boss, will give us some empirical evidence that bolsters that proposition, but I think that proposition is self-evident. In the DNA of the United States, let me just remind you briefly that our Constitution was created to solve an international law problem, the failure of the United States to honor the Treaty of Paris, and namely to respect property and contract rights that had been framed before the Revolution. And the price, if you will, of our independence from England was enduring respect of those entitlements. Second point is that property and contract recognizes that there are unforeseen circumstances. There are many doctrines that take this into account. So that stability is not the same thing as stasis. The issue is how do we take account of unforeseen circumstances such as an economic crisis. And the third general point is that economic crises are unforeseen in their timing and severity, but not in their existence, that we can count on them occurring. I realize people in the real estate market didn't believe this for a while, but most people do understand that prices do go down on occasion. So the question is not, does an economic crisis amount to an unforeseen circumstances that require adjustment of entitlements? The issue is, does an economic crisis create the kind of broad excuse for judges to interfere in economic entitlements? And we should consider judges in competition with the other branches. There are some obvious ways in which we, in the United States, and as far as I know, in every developed market-based or social democratic legal system in the world, where we tolerate redistribution in response to changed circumstances. One is bankruptcy. Another is the widely recognized right of the state to expropriate property as long as there is a legitimate purpose and they pay for it. But both of these examples are examples based on both legislative and executive authorization, where courts execute legislative commands rather than on their own deciding that people should be relieved from their debts, that property ought to be transferred to somebody else on their own. So what are the arguments for a judicial role in advance of the executive and legislative branch? I will describe two that I've encountered and then criticize both. The first was articulated by a very distinguished jurist, Chief Justice Ehud Barak of the Israeli Supreme Court, who a few years ago when we were on a panel together, it would be really demeaning to him to say we were on a panel together. He was on a panel that I happened to be on, where he was asked to talk on law in a time of crisis, and rather than talking about terrorism, he talked about hyperinflation and the role of Israeli courts in responding to hyperinflation. He made the argument that single-digit inflation is normal background noise. Double-digit inflation is something that is a concern, a challenge to the system, but that we can expect normal governmental processes to respond to those challenges. But when you get to triple-digit inflation, which Israel has known, we haven't in the last century or so, that the other branches of government are no longer capable of responding with sufficient alacrity to such a crisis, and the courts, by compulsion, by default of the other branches of government, have to step in. And he used this, of course, as an example. He was trying to make a general point with a single example. The critique that I would suggest of this argument is that there are constitutional systems, and Israel, I think, is one, where the judges have to get out ahead of the other branches because of certain structural commitments. The proportional representation plus the lack of an independently elected government which is a common model throughout much of the world. That's to say, you don't have a president who runs and forms a government. You have someone who puts together a coalition based on the distribution of parliamentary power, and the system is structured in such a way that there will always be diverse and disparate parties that will form a coalition. That this does create an inhibiting effect on rapid government response to serious crises. Essentially, in order to respond to a crisis, a government has to surrender its right to govern because it will create a new election. And under these circumstances, you can understand, I think, why a default to the judiciary might be appropriate. But there are other systems, Westminster-type systems, including the U.S. variant, where that structural argument isn't true. And in general, the evidence, I don't think, is there that we need the courts to respond advance of the executive and the legislature to economic crises. I think the most recent 2008 crisis is a pretty good example where, based on legislative authorization, the executive branch put together a package that many might find objectionable in the particular, but at least nothing seriously bad happened. Maybe bad precedents were set, maybe rather disturbing redistributions took place. I put that aside. The point is it wasn't disastrous. The other argument is articulated by yet another Virginian absent here, a beloved absent colleague, Saul Levmore, who was Paul and my colleague for many years before he lost his way and went off to Hyde Park. And he developed an ingenious argument. Saul, like, I guess I should say Dean Levmore. Dean Levmore, like all three of the panelists, are interested in what we might call the Virginia School of Political Economy, the public choice theory developed by Jim Buchanan and Gordon Tullock here in our economics department at Virginia, and made the quite straightforward argument that capture is a serious problem, that one of the ways to respond to capture is to destabilize the entitlements that are created through capture. He was discussing specifically litigation, like the reparations litigation, like the suits against tobacco, the suits against gun manufacturers, the idea that people could, through common law developments, common law tort concepts, obtain compensation for activity that was clearly legal at the time it took place, however objectionable it might be. His argument was in defense of such litigation, saying that without the threat of judicial instability, entitlements obtained through public choice described processes that allow capture by concentrated minorities will remain entrenched. And unentrenching these entitlements is a good thing. With respect and reverence for my smarter younger brother, Dean Levmore, I would say that there are at least two problems with his argument. One is it's hard to tell the difference between entitlements created by capture and entitlements created by the normal operations of the system. Secondly, I think, as brilliant as he is, he has a naive conception of how civil litigation works. And I would argue that capture through litigation is another public choice problem. That just as legislatures can be captured, just as agencies can be captured, assuming something less than omniscience on the part of judges and assuming that there is value to having a particular kind of attorney, a particular kind of advocate, that there's no reason to believe that the quality advocacy will always be on the side of the good of the public interest. And that without taking into account public choice distortions through litigation, the argument fails, in my judgment. So this is a negative argument rather than a positive argument. You have to start with the background assumption that stable entitlements are good, and then knock down arguments and, supporting judicial destabilization of those entitlements, and this is my effort to do so. Thank you.
Thank you. I'm grateful to all of you for being here on a Saturday afternoon. So this panel is supposed to address economic uncertainty and the role of courts. We know a lot more about the first than we do about the second. That is to say, we know about the effects of uncertainty, especially uncertainty about property rights on the economy. We know less about the extent to which institutional arrangements can guarantee security of property, and even less still about whether they can create secure property rights where they don't already exist. There are very strong theoretical reasons, as my colleague Paul Stephan told us, to believe that property rights are a first-order determinant of the health of the economy. Indeed, Adam Smith linked investment and growth to what he called the security of property. It also seems reasonably clear that the security of property rights is connected to the structure of government. When we compare societies around the world with despotic governments to those with limited governments, the latter usually have better property rights and are usually more prosperous. And that would be true if we compare, say, the Netherlands before and after independence from Spain in the 17th century, or if we compare Zimbabwe and Botswana today. Now, we can look at the question more systematically, and many scholars have set out to do just that. I'm going to draw on a large body of work to which many scholars have contributed, and I've posted a couple of citations to some review articles on the conference website for those of you who are interested. A simple starting point is to ask whether, as we look around the world today, the security of property rights is associated with the degree of economic prosperity. When we set out to do that, we quickly discover that we can't determine the security of property rights just by looking at the statute books. In general, non-communist countries have formal protections for property rights. But we probably share an intuition that even if the formal rules about property are the same in Luxembourg and Paraguay, nevertheless, property is more secure in Luxembourg. And in addition, I'm going to have to use the term property rights pretty loosely because, as we all know, there are many, many things a government can do to interfere with property rights other than outright theft. It can regulate to the extent that property can't be used profitably. It can devalue the currency to the point where paper assets become worthless. It can allow politically favored entities to play by different rules than everyone else. So I will use the terms property rights and economic freedom broadly to refer to the absence of those forms of interference. Now, various organizations and scholars try to measure the de facto security of property rights. Companies like Political Risk Services create survey-based measures for the use of private sector clients who invest abroad. The Heritage Foundation calculates an index of economic freedom that incorporates some of these other forms of interference with property rights that I just discussed. Now, in general, those sorts of measures correlate quite highly with economic prosperity. Interestingly, those measures of economic rights tend to correlate more highly with prosperity than do measures of political freedoms. So compare, just to take one example, Morocco and Singapore. Both have a parliamentary government, but both are somewhat intolerant of dissent. They have identical scores on two of the most common measures of political freedom: Freedom House's Index of Political Rights and its Index of Civil Liberties. However, Singapore scores much more highly than Morocco on the Heritage Foundation's Index of Economic Freedom. Singapore is a much wealthier country. Indeed, its per capita GDP is more than 10 times that of Morocco. But now we get to the hard part. Why does Singapore, which has a similar level of political freedom, have more secure property rights than Morocco? Indeed, why does it have more secure property rights by most measures than Italy, which has far more political freedom? And even more importantly, Could Morocco get as wealthy as Singapore by altering its government structure in some way to limit its ability to interfere with property and other economic rights? One traditional answer, as we all know, goes back to Montesquieu, and it looks to institutions like federalism and an independent judiciary as checks on governmental power. The idea is that governments are always tempted to engage in short-run interference with property rights and other economic freedoms for temporary political advantage, even at the cost of long-term harm to the economy. And the more constrained the government is, the harder it will be for it to engage in those short-term strategies, and indeed the harder it will be for capture, as Professor Stephan has spoken about, to take place. And broadly speaking, that's the story we tell ourselves about the founders. They wisely set up a government with many checks and balances that limit the federal government's ability to interfere with property and contract rights. A piece of anecdotal evidence for that theory is the difference between England and France in the early 18th century. After the Glorious Revolution, England's monarchy was considerably more constrained than the monarchy of the Sun King and his Bourbon successors in France. Now, during that period, England developed robust financial markets, improved its commercial markets, and moved ahead economically of France, which fell behind. Well, there is, though, an alternative view of the history, and the alternative view is that we've got the causation backwards. Societies don't respect property rights and become rich because they have constrained government. They get constrained government and secure property rights because they are rich. Once people start to accumulate property and insist on a less intrusive and predatory government, they tend to be able to get their way. Now, a piece of anecdotal evidence for that theory is the Korean Peninsula. Before World War II, of course, Korea was under a single government, and the North and the South had, broadly speaking, a similar level of economic development. After the war, the country is partitioned into North and South Korea, and both are initially ruled by autocrats. But the North's autocrat decided to pursue socialism, while the South's autocrat chose to pursue a market economy. The South grew prosperous, and the North grew impoverished. Eventually, the citizens of South Korea would no longer accept autocratic rule and created a more limited form of democratic government. Now, clearly, those two stories have very different implications for how a country can go from low to high security of property and from poverty to wealth. The first suggests that you need to tie Leviathan down, and then you will get prosperity. The second suggests that you need to get lucky and have the right Leviathan, or at least persuade Leviathan to adopt pro-growth policies, and eventually you'll get limited government in the bargain. Well, so far I've provided anecdotes. Do we have any systematic evidence that can tell us which story is correct? Well, we have systematic evidence, but unfortunately it's not conclusive. Here's a piece of evidence in favor of the constraining government causes prosperity hypothesis. If we compare countries around the world, there are quite systematic differences between those that were colonized by England and those that were colonized by France, Spain, or other continental powers. In particular, former English colonies tend to have larger and more liquid financial markets, and their economies also grew faster in the post-colonial period from 1960 to the 1990s after controlling for the initial level of development. That's important evidence for two reasons. First, the English theory of government, which it transported to its colonies, was one of limited government and secure property rights. The French and Spanish theory, by contrast, was of a strong central state in which the government was not so constrained in pursuing collective ends. Second, and equally important, we don't have to worry about reverse causation. The fact that Australia is a wealthy country today did not cause England, rather than Spain or France, to colonize it. Wealth, in that theory, or in those results, does not cause good institutions because it didn't cause colonization. So that's good evidence in favor of the proposition that institutional constraints cause wealth. But a piece of evidence in favor of the prosperity causes constraints on government hypothesis is that most poor countries in the middle of the past century had more or less despotic governments. In some, like South Korea, Taiwan, and Chile, the despot chose pro-growth policies, and the country became prosperous relative to its neighbors, and later developed more constraints on governmental power. Well, here's what I take away from the analysis. I'll confess that I am drawn to the first of the two hypotheses, but here's what I take away from the evidence itself. There are two common packages consisting of institutions, policy choices, and economic outcomes. One package includes constrained government, generally pro-growth policies, secure property rights, and prosperity. The other includes unconstrained government, generally anti-growth policies, low protections for property rights, and poverty. Each package is common, and in each one, the institutions, the policy choices, and the economic outcomes are mutually reinforcing. Now, interestingly, once you start to mix and match pieces from each of the packages, you create some tensions. So take China, which has fairly unconstrained government, somewhat more pro-market policies, low but improving property rights, and increasing prosperity, starting, of course, from a very low level. This package is not mutually reinforcing, and China is likely to face ongoing political conflicts despite the best efforts of its rulers to hold on to unconstrained power. Similarly, our system of checks and balances, federalism, an independent judiciary, etc., does not prevent episodic interference with property rights in the United States, such as ignoring the normal rules of creditor priority in the Chrysler and General Motors bankruptcies, enacting a health care law that requires citizens to buy insurance whether they want to or not, or playing favorites with certain industry sectors or individual companies. But the most recent outbreak of those interferences produced a quite powerful popular backlash that may operate as a more potent constraint than federalism, bicameralism, you name it. I'll close with a final observation. Because the literature on economic development is concerned primarily with how to get poor nations out of poverty, it has tended to see the demand for good policies and good institutions as always rising with the level of wealth. And history certainly suggests that a country with a middle class is more likely to demand good institutions than one without it. But the experience of Europe and America over the past, say, half-century suggests that the relation between wealth and the desire for limited government may not be linear on all parts of the spectrum, that like many economic relationships, it may at some point become curvilinear. Once you reach a stage where the marginal voter owns a house, a car, and a flat-screen TV, the marginal voter may become less interested in growth and more interested in stability. And of course, the eternal justification for larger and more powerful government is stability. Perhaps then, paradoxically, limited government may be very popular until it produces an extremely high level of success for its society. Thanks.
Well, somehow it feels appropriate that I'll be the last speaker of scheduled speaker of all the panels, not just because my last name starts with ZYW. I also looked at the schedule and I said, why didn't they just skip all them out and just have this at George Mason rather than trucking all of us down to here? And then I thought, well, no, it would have made even more sense. If we're going to have a bunch of Volokh conspirators, we should just had a cyber virtual symposium with Randy and Adler and myself. But then I realized it was just an excuse for me to come back to UVA, to my alma mater, and I wore my tie and everything, so I could come back to the old homestead. And the question that's presented for this panel is, should judges protect private property rights and constitutional rights the same in times of crisis as they do every other time, in ordinary times? And what I take away from the most current experience is that not only is the answer yes, but the answer is that judges should protect private property more in times of crisis than in ordinary times, both as a matter of good economic policy as well as preventing precedents that give rise to a predatory state. So let me unpack that. First, in a nutshell, I think Paul Mahoney, really did a marvelous job giving you an overview of the literature. But the basic idea is Hayekian, which is that the basic idea is that the world is in flux. It's a miracle that anything happens, really. People talk about sort of the miracle that milk shows up in your refrigerator on any given day or in the cafeteria. If you think of all the chain of coordination that needs to be done to get milk from for farmers to even know to make dairy cows, right? And you think of all the coordination in that chain and all the signals and all the flux that's going on in trying to create an economy that works. Hayek's observation is, given the level of discoordination, given the level of disequilibrium, the world's constantly in disequilibrium, what we really need to focus on is minimizing the amount of variables that people have to deal with. And obviously, one of the big variables that people have to deal with is the legal regime. And so one of the things you take away from Hayek is what's of crucial importance is, in a world that is dominated by flux, if you want to have economic activity, you've got to have as much stability in things like the legal regime as possible. Just think about, for instance, what it takes to make a loan. And what we've seen is that credit markets were obviously, blown up and very slow to recover. And we can understand why credit markets have been so slow to recover. In order to make a loan, you've got to basically be able to do two things. Either you've got to be able to price the risk of the loan accurately, or you've got to reduce your risk exposure. What we saw over the past couple of years in response to or as a rationalization from the financial crisis is a huge amount of instability and chaos that makes it very difficult for people to price loans. And as a result, what we have seen is that lenders have responded by reducing their risk exposure, by lending less and lending to fewer people. So think about, for example, the Credit Card Act, one of the most horrible things that's come around in the past few years. And one of the things that the Credit Card Act does, it does a lot of things, but one of the things it does is it makes it more difficult to raise interest rates when somebody's risk profile changes. It does a lot of other things it does that, but basically that's what it does. What's the implication of that? Well, first, if you can't raise somebody's interest rate when they become more risky, what do you predict that credit card issuers will do? They'll just raise everybody's interest rates ahead of time. And that's exactly what we've seen come out of the market. If you can't price risk accurately by raising interest rates, what do? You reduce risk exposure. You lend less and you lend to fewer people, so that a lot of people have seen their credit lines slashed. And Jamie Dimon, the CEO of JP Morgan, last year in a shareholder letter said that 15% of JP Morgan Chase's customers who had previously received credit cards would not be able to get credit cards anymore. You have to reduce your risk exposure if you can't price your risk accurately. And so in that sense, it'd be a miracle if we did see life in credit markets. You pile on top of that healthcare reform, the possibility we had for a cap and trade for a while, a really extraordinary growth in the regulatory state. And what you're talking about is the whole tax showdown that came about at the end of December, everything that's in Dodd-Frank. You start adding all that up and you just think, what would it take to try to figure out how to make a loan, how to price the risk of a loan that's going to be repaid in a year or 5 or 10 years from now when you have no idea what the legal regime is going to be like? Third, when judges fail to enforce rights, it creates a target-rich environment for opportunistic politicians. And as the previous speakers have noted, basically the reason we have private property rights and constitutional rights is to constrain politicians. And when you fail to constrain politicians, they take advantage of that. GM and Chrysler being the obvious example, where the government intervened to plunder the secured creditors in Chrysler, basically stealing money from the secured creditors, who included, incidentally, the Indiana Teachers and Firemen's Pension Fund, basically destroyed the settled rules of bankruptcy just so they could transfer a windfall to the UAW. What this ends up doing is creating political risk, and now we've seen at least one paper that talks about the political risk that was created by Chrysler and General Motors. I wrote a column in the Wall Street Journal called "Chrysler and the Rule of Law," where I said that we never had to really worry about political risk in the United States, and that the sound